Welcome to meeting number 99 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. To prevent disruptive audio feedback incidents during our meeting, we kindly ask that all participants keep their earpieces away from any microphone. Audio feedback incidents can seriously injure interpreters and disrupt our proceedings. A reminder that all comments should be addressed through the chair. And before I move on, I want to mention one thing quickly. We had an invitation from the foreign delegation of Norway. The Norwegian Parliament Standing Committee on Justice will be visiting Ottawa from April 7th to 9th. The Norwegian delegation consists of members from 6 political parties. They would like to meet with members of our committee to discuss common interests, such as civil preparedness, protection against future threats, including threats against critical infrastructure. So I just wanted to ensure that we have some interest in that regard from all parties, if that's possible. That'll,
we're going to do an exchange?
That's a good idea. Yeah. So I'll say we accept the invitation for April 8th, and hopefully we'll have some people there to have a discussion with this group. Okay, go ahead.
Thanks, Chair, and I think that's a great idea. But could you just explain, being that I'm the new one on the committee, just how the notice and whatnot will work for that? Will there be translation? What's kind of the circumstances to which we'll have that engagement?
Mr. Clark.
So that will be an informal meeting with interpretation. The meeting would be an extension of the regular hours that we have on that day. So it will be from 5:30 to 6:30, just after our regular meeting.
I actually thought you were talking about interpretation for a different language. That's okay.
They speak English.
They speak English very well. All right, study on Bill C-26. Pursuant the order of reference of Monday, March 27, 2023, the committee resumes its study of Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts. Today, the committee commences clause-by-clause consideration. I will now welcome the officials who are with us. They are available for questions regarding the bill, but will not deliver any opening statements. Department of Industry, Andre Arbor, Director General, Strategy and Innovation Policy Sector. Wen Kwan, Senior Director, Spectrum of Telecommunications Sector. Department of Public Safety and Emergency Preparedness is Colin McSween, Director General, National Cyber Security Directorate. Kellyanne Gibson, Acting Director, National Cyber Security Directorate. Thank you for joining us today. So we're going to move right into clause by clause. The chair calls clause 1. Shall clause 1 carry? Yes. Mr. Lloyd.
Just before, as we get started, I just want to move just a notice of motion, so won't get into a debate on that today, but I just want to, in light of recent news about a Montreal food bank having to call in police officers to deal with hundreds of additional Montrealers seeking food, and given that we know that the carbon tax does have an effect on contributing to food, and that food insecurity is indeed a public safety issue in this country, I'm just going to put on notice my motion that we report to the House to spike the hike and axe the tax so we can bring food prices down, so police can deal with the very real issues that we've talked about in this committee, instead of having to go to food banks to provide crowd control for the hundreds and thousands of hungry Canadians who are using food banks in this country.
Thank you, Mr.
So with that, thank you, Mr. Chair.
Thank you, Mr. Lloyd. Mr. Kurek? You good? Okay. So I shall repeat, shall clause 1 carry? Clause 2. Block 1. We're here? Oh, sorry. Yeah, shall G1 carry?
No, yeah. She needs to move it.
It was so moved.
Someone needs to move it.
We'll get through this quickly.
We will get through this. This is my first time, so bear with me. So, Mr. Kurek, please, first.
To the amendment, but I think somebody needs to move it, and I don't plan to move a government amendment, so is that?
Yes.
So.
Oh, sorry, Mr. Julian.
Yeah, just on a point of order, this will move smoothly, and I hope it will make a lot of progress today as we move through each of the articles, have it move, and I think it's fair to say, as you go through this process, you'll enjoy it as well, as we all will, over the course of the next few hours. But I would ask that you proceed very methodically so that we can keep up with the paperwork, because we're managing, of course, the bill, the amendments list, recommendations around each of the amendments as well.
Thank you, Mr. Julian, and I will slow down, Mr. Julian. Off to a quick start. Might be a slow finish, but okay. You're here? Mr. You're here.
Thank you, Chair. So I'd like to move the government's amendment number 1, which touches on 15.1. We would remove "in the opinion of" and add to 15.11 a reasonableness standard. And we've had organizations reach out, including the Civil Liberties Group, that wanted a reasonableness standard in the GIC order-making power. And I'll leave it at that for now.
Mr. Kurek, please.
Thanks very much, Chair, and thanks for the government for moving this amendment. And I guess I would ask our officials in relation to G1. It seems to me that this would be something that makes good sense. However, I'm just curious in terms of similar where governor and council has the power to make appointments. If the change that is being suggested by the government lines up with what would be the case in other areas of both this act and across the areas of responsibility, because I think that one of the reason why I ask that question is just to make sure that it's consistent, that it's understood, and that there is a definition as to what reasonableness would be in determining how a governor and council appointment, which for those listening is basically the minister making that appointment, what that looks like, and the difference between what was initially proposed and in light of what my Liberal colleague has talked about, some of the civil society groups that have asked for this reasonable clause. So I'm wondering if you could maybe unpack a few of those things, and I'm also very curious as to if this is in conflict, continuity, or makes any changes to other aspects of where governor and council appointments would be applied.
Thank you, Mr. Chair, for the question. I'd like to organize my answer in 2 buckets. One is where this comes from and the lengthy case law that defines what reasonableness is, and then how this compares with some of the other proposals, including a notion of proportionality would be my second bucket there. So in terms of reasonableness, so there is decades and decades of case law established by the Supreme Court on what reasonableness means in an administrative law context. And that's exactly what we're talking about here with orders in council. They do not deal with the appointments of personnel, but deal with orders to telecommunications service providers, in particular on whether to limit the use or restrict certain forms of equipment, including high-risk vendor equipment. So there's extensive case law on this, and the Supreme Court's 2019 Vavlov decision goes into great detail specifically on what the criteria of a reasonable decision is or not. Those criteria, to get to my second bucket, include principles of proportionality. So that's in the Supreme Court's decision. This amendment does not bring out proportionality as separate text, so it does not say reasonable and proportionate. It doesn't do that because proportionality is already bundled into the reasonableness standard as established by the Supreme Court. So first, it's there. Secondly, when used on a standalone basis, that is something that is only used in a charter rights context. The Oakes test established by the Supreme Court for reasonable limits on charter rights includes proportionality, but it's specific to charter rights and not, say, the regulation of Bell or Telus or Rogers. And it includes a standard called minimal impairment, and it asks the government to look at the least intrusive means of accomplishing an objective. So, for instance, in this context, it could say, rather than have a regulation to restrict certain equipment, maybe you should have a subsidy program to pay the companies to remove that equipment. If that were applied in a administrative law context such as this, there would be the risk of orders being overturned by accident or unintentionally. But to the extent there are concern about charter rights, the decisions of the Supreme Court already apply. Thank you.
If I could ask a follow-up, just so, and I appreciate that, and just to welcome and thank you to all of you. I am newish to the committee, although I did serve for a segment of the 43rd Parliament. But thank you all for offering your expertise to the committee today. Just in terms of then the difference that. And you talked about the standard to which what goes into reasonableness, but the difference that makes in terms of practically in the context of C-35, the amendment versus what the original text would have empowered the governor and council to do.
Thank you, Mr. Chair, for the question. I would say that the difference is more in the zone of providing greater certainty. So the requirements of the Supreme Court that decisions be reasonable exist irrespective of the text that is in the law itself. Those are fundamental principles that apply to any administrative law context. What this does is it makes it clearer in the text of the bill itself that those principles apply.
Shall G1 carry? BQ1. And I want to read, if BQ1 is adopted, CPC 1, page 3 of the package, G1.1, page 3.1 of the package, G3.1, page 13.1 of the package, G4, page 16 of the package, G4.1, page 16.1 of the package, G4.2, page 16.2 of the package, G4.3, page 16.3 of the package, CPC 6, page 17, and CPC 12.1, page 36 of the package cannot be moved due to a line conflict. So,
Maybe she wants to move. She needs to move it.
okay. You need to move it?
Merci, Monsieur le Président, et je vais...
Thank you, Chair. So I'd like to move BQ1. You've mentioned all of the different amendments that cannot be moved if BQ1 is adopted. It's quite simple. With BQ1, we want to remove one word that comes up several times in the bill. And I'm not going to speak for my colleagues, but perhaps they also had an intention to do something similar to BQ1. So basically, it has come up several times during our hearings that businesses and companies who came before us said that there's a fear about the scope of ministerial powers under telecommunications security. There's a concern vis-à-vis privacy as well. So for adding a criteria of proportionality and the obligation to consult experts would mean that the minister would not be using issues to take disproportionate or intrusive actions. So that's why we want to remove the word including that comes up several times. That could beef up basically the bill and perhaps restrict the ministerial authorities which have been granted under this bill. So I'd like to invite my colleagues to vote in favour.
Mr. Shipley.
Thank you. Thank you, Chair. We will be voting against this amendment, and when it gets time, we will be drawing our own amendment, CPC 1, in preference of voting with G 1.1.
Hi, Mr. McKinnon, please.
Thank you, Chair. I'd like to move a sub-amendment to this amendment. I'd like to modify paragraph A of this amendment, which replaces line 15 on page 1. I would like to replace that text with the substance of G 1.1, which adds, which replaces lines 15 and 16 on page 1 with similar text, but adds the word degradation. So basically, it just adds the word degradation to the list. And anyway, I'd like to move that.
Thank you, Mr. McKinnon. Ms. O'Connell, please.
Thank you, Chair. I think what Mr. McKinnon was trying to do is what kind of the place we'll get to in G1.1. So it might be simpler just to defeat this amendment and then deal with the following as they come. But before we even get into that, perhaps I'll ask the officials, one of the concerns, while I appreciate Madame Michaud's comments, and it is something we heard in terms of making sure that powers are not in this bill, that they are not so vast. However, when we're talking about cyber and cyber threats, the concern is that by the time we print something on paper and it becomes law, it may already be outdated. So perhaps to officials, could you elaborate on whether or not the limitations around the limits around only what can be considered might be the intention of the bill, but that there is still flexibility given the constant changing nature of threats? Could perhaps officials elaborate on why there are concerns or why there might need to be some parameters around this language?
Thank you, Mr. Chair, for the question. Certainly the government appreciates the concerns from stakeholders about ensuring that there are guardrails established in the bill. Would start from the point of view that, first of all, anything within the bill needs to be in order to protect the Canadian telecommunications system. So anything that involves surveillance, for instance, is just entirely separate from that issue. In terms of the notion of the word including, so the bill was crafted with the intent to try and keep pace with an evolving technological landscape, but it's hard to know exactly what will evolve over time. G1.1 looks at the word including, but reframes it in terms of any threat. So rather than anything, it's focusing on preventing threats, and then adds back in the word adds in the word degradation. Just that was a risk factor that wasn't in the original text, that if the word including was removed, could be a vulnerability down the road.
Any more discussion on the sub-amendment? Okay.
I think they're just talking about.
Shall BQ1 carry? No.
Mr. Chair, I believe we have to vote on the sub-amendment.
Okay.
Rappel au règlement, Monsieur le Président, est-ce qu'on pourrait...
So, point of order. We can vote on the sub-amendment, or Mr. McKinnon could simply withdraw that in light of the discussions we've had, and if we could perhaps have a recorded or on-division vote on BQ1, that would be much appreciated.
You're willing to withdraw your sub-amendment based on the conversations that we just had?
Yes, Mr. Chair, I will withdraw the amendment, sub-amendment.
Thank you. Shall BQ1 carry? No. You ask for a vote?
Yes, recorded vote.
Yes. A recorded vote?
So, okay, recorded vote. Ms. O'Connell?
No.
Mr. Biddle?
No.
Mr. Gaillard?
No.
Monsieur Chiffquet?
No.
Mr. McKinnon?
No.
Mr. Shipley?
No.
Mr. Lloyd?
Nay.
Mr. Mutz?
No.
Mr. Carrick?
Opposed.
Madame Michaud?
En faveur.
Mr. Julian?
En faveur.
Merci.
2 yeas, 9 nays.
So BQ1 is defeated. CPC 1 can only be moved.
That's okay. That's good. This one here.
Okay, sorry. Also, if CPC is adopted, G 1.1 cannot be moved due to a line conflict.
Chair, we'll be withdrawing that. In favor of the language in G11? Yeah, we do. Yeah, we do.
So G 1.1?
Go to G1.
Okay,
So no need to do that because,
it's all done?
yeah.
Okay, so NDP 1?
No.
Carrie?
He needs to move it first.
Oh, you had to move it. Yeah, sorry. Ms. O'Connell, sorry.
You lost me there.
Don't feel bad, I was lost too.
Okay. So if you could walk us through the next step.
Yes. G 1.1. Is that what you asked me?
So it needs to be moved.
So for CPC 1, you're saying that there's a line conflict?
They
You withdrew it, okay. There we go, thank you. That was the missing part.
So someone needs to move it.
O'Connell?
Thank you, Chair. Sorry, we're all getting back into the groove of this, but G 1.1, again, it just cleans up the language in terms of the concerns that were rightly addressed, but also keeps in the language of including, just to ensure that the legislation can keep pace with the evolving nature of threats, and adds in the word degradation that I think officials already spoke to, so I won't speak further to that unless there are questions.
Any other discussion? Are we good? Good? Good?
No, so it's G.1.
Carry.
Point 1 carry.
Shall G1 carry?
G1.1.
G.1, sorry.
Point
1.1.
Yes. And again, Mr. Chair, just if you can slow it down, that's very helpful.
Okay, thank you.
Carry.
So carried. Next one. NDP 1. Are you good? You good?
So I'm not going to make a filibuster, Mr. Chair. I'm moving NDP. Oh, sorry.
Slow down, Mr. Julian.
Okay,
So if
Just clarification, please, if NDP 1 is adopted, G 1.2 cannot be moved
because of a line conflict.
because of a line conflict. Now what?
So he needs to move it.
That,
Mr. Chair, wanted to respect the speed that we're setting. So yes, I move NDP 1. We heard many witnesses, Mr. Chair, as you recall, from a number of sectors talking about ensuring consultation with prescribed persons and entities in a way that ensures that any orders are subject to the appropriate consultation process and also the appropriate transparency. I particularly flag the president of the Privacy and Access Council of Canada, who talked about the importance of having that consultation with prescribed persons and entities. So this would change and insert in terms of any government order on telecommunications systems, ensure that those consultations take place. So I move NDP 1, and hopefully with the witnesses that were very clear in this regard that it will receive the support of the committee.
Thank you, Mr. Julian. Ms. Michaud, please.
Oui, merci, Monsieur le Président.
Thank you, Chair, and thank you, Mr. Julian, for moving this amendment. I'd like to know from the witnesses, hypothetically speaking, if we replace this amendment by just a sentence on line 15, they would say after consultation with the appropriate persons and entities, would that be more efficient? Or would NDP 1 be more efficient because it's more complete and it has more elements involved? What would be best, do you think, in terms of amendments here?
Thank you, Mr. Chair. Pardon. Merci, Monsieur le Président, pour.
Thank you, Chair, for that question. The difference between the text really depends on whether there's a regulatory process at the outset before the consultation period begins. Given the number of stakeholders, etc., who have an interest in this subject, and the fact that, generally speaking, our regulatory procedures are open to everyone, the possibility of avoiding a consultation phase to try to specifically register certain parties could pose certain obstacles in the overall regulatory process. So having a slightly more flexible text which would invite the consultation period to take place beforehand would be more efficient.
Merci.
Please.
Thank you, Chair. We will be voting against this amendment. Sorry to disappoint my NDP friend, but we prefer the language regarding consultation in G 1.2 and 3.2, which we will be supporting.
Mr. Gahir?
Likewise, to Mr. Shipley, we'll be supporting the language that we are proposing in 1.2.
Anybody else? No more discussion?
Call for a vote.
Shall NDP 1 carry?
Recorded vote, please.
Ms. O'Connell? No. Mr. Biddle?
No.
Mr. Gahir?
No?
Mr. McKinnon?
No.
Monsieur Chiffrier?
No.
Mr. Shipley? No. Mr. Lloyd?
No.
Mr. Mutz?
No.
Mr. Kurek? Opposed. Madame Michaud?
En faveur.
Mr. Julian?
En faveur. Yes.
2 yeas, 9 nays.
NDP 1 defeated. Gonna move her to G 1.2. Mr. Gahir?
Great. Thank you, Chair. So this is related to NDP 1, but alternative language, and it's G 1.2. So we're moving to amend that Bill C-26 in Clause 2 be amended by replacing line 17 on page 1 with the following, that the Council may, comma, by order and after consultation with the persons the Governor and Council considered as appropriate. That's the amending language. And again, this is alternative language to NDP 1.
Ask for everybody in favor. 1.2 carry. NDP 2. If NDP2 is moved, CPC2 cannot be moved as they are identical. Yeah. He's moving. Mr. Julien, do you want to move that?
I would love to, and my coalition partners in the Conservative Party, I hope will vote for this as well. You'll recall, Mr. Chair, that a whole range of groups that came before this committee, and I'll just cite a number of them: the Privacy and Access Council of Canada, Open Media, National Council of Canadian Muslims, Ligue des Droits et Libertés, International Civil Liberties Monitoring Group, the Canadian Civil Liberties Association, all urged that provisions of the order be within the purposes of the bill, be subject to being reasonable and proportionate to the gravity of the threat of interference, manipulation, or disruption. And so this is a concern that has been raised to have guardrails in this legislation. It's important. We heard much testimony to the effect that this is an important guardrail to ensure that provisions of the orders that we're giving, the powers that we're giving to the ministry, that they be exercised in an appropriate way. So this issue of proportionality is extremely important, and that's why I move NDP2.
Thank you, Mr. Julien. Mr. Lloyd, please.
I just want to propose a sub-amendment, given the language in G1.1 that was approved. I move that we sub-amend, following the word manipulation, add a comma, remove the word or, and then following the word disruption, add the words or degradation.
Thank you. Mr. Couric on the sub-amendment or the amendment? On the original amendment?
Mr. Lloyd, maybe repeat that, and then could we have the officials comment on what that would implicate?
Mr. Lloyd, could you repeat it, please, for the officials?
Yes, I'm proposing that we add a comma following the word manipulation, remove the word or, and then add the words or degradation after disruption.
Mr. Gahir, you made reference to the officials. Do you want to ask them a question?
Maybe talk about how that would change the language, the effect of the language.
Thank you, Mr. Chair, for the question. Starting with the existing text of NDP2, so it sets out standard or language around reasonableness and proportionate, and brings up proportionate as a distinct concept from reasonableness. This has some substantial risks to implementation down the road. I do appreciate the intent and that the concern over adequate guardrails. Would note that the criteria for reasonableness as established by the Supreme Court has principles of proportionality embedded within it, and that's outlined in case law and the 2019 Vavilov decision in particular. Bringing out proportionate separately from reasonableness and inserting it into the bill has different connotations than the plain language understanding of the word proportionate. And as a standalone concept outside of an administrative law context, is only used in a charter rights context. So my understanding, based on any of the testimony that I've seen or submissions, it's not the intent to apply a charter rights standard to the regulation of mundane equipment issues in the telecom sector. So that is my understanding. That's not the intent. However, in writing it this way and importing that Supreme Court language in this way, there's a risk of that down the road. Thank you.
Thank you. And now we have Ms. O'Connell, please, on the sub-amendment.
Thank you, Chair. I have no issues with the sub-amendment, but I can't move an amendment of my own now because of that. So I will say, and then I'll come back to it after we deal with the sub-amendment. But in terms, we can't support this based especially on what officials had just said, if the word proportionate is in there, mainly because of the legal context of that word. And since G1 was adopted, which added in the reasonableness clause, which I think is what everybody wanted. So we can't support the sub-amendment or the amendment if it has the words proportionate in the text, but we could support overall if that is taken out. And I think we should delve into this a little bit when it's appropriate in terms of that proportionate language and what that actually means for the bill. But again, I know we're kind of on the sub-amendment, so I have to wait for that to be dealt with.
Mr. Motz, please.
Thank you, Chair. And I was going to suggest that we deal with the degradation first, and then I would, as the sub-amendment, and then we allow Ms. O'Connell to present her additional sub-amendment.
Okay. I have Mr. Lloyd. Are you okay?
Goes to a vote, Chair.
Is everybody good? Call for a vote on the sub-amendment? Did I hear chair from somebody? No? Oh, sure. Okay. So we'll call for a vote. Unanimous? Okay, so we're back to the amendment. Yes, Ms.
Or
O'Connell.
sorry, on the original amendment.
Original amendment.
I would move a sub-amendment to remove the word proportionate. And that would be in the 1.1. And the rationale, if everyone is clear with.
Mr. Chair, just to clarify, would that be to remove the words "and proportionate"?
Ms. O'Connell?
Sure. But I think the important piece there is that we are removing the term, that we keep in "be reasonable" to the gravity of the threat, and just removing "unproportionate." Again, what officials just spoke to earlier was that the terminology proportionate in the legal sense is different than just, from us speaking it, which might seem very reasonable. But because we moved Government 1 amendment that added the reasonableness clause, we feel that moves to the heart of the intent of what the concerns are without getting into the legal and charter ramifications or usage of the word proportionate. So we can support these changes, but not without the removal of that of proportionate as a terminology within this bill.
Thank you. Mr. Motz, please.
Thank you, Chair. I'm going to go back to the officials again. Mr. Arbor, you had indicated the charter concern, and I mean, the whole bill has to be charter compliant, obviously. So can you explain to us again with specifics on what you think the concern would be about having proportionate there, other than it might open up a more of a charter argument, but specifically, is there an example you can think of that comes to mind that would help clarify the concern? Thank you.
Thank you, Mr. Chair, for the question. First, yes, so the bill has to be, and anything stemming from it would have to be charter compliant. So any order coming from it would have to be proportionate as established by the Supreme Court, regardless of the text of the bill itself. The issue with taking the word proportionate out of its charter rights context and applying it to administrative law decisions writ large is that it takes charter rights criteria for reasonable limits on charter rights and applies it to more mundane commercial activities of telecom service providers. Give you a specific example. So one of the core factors when the Supreme Court does a test of reasonable limits on charter rights is something called a minimal impairment test. And it basically asks, if you're going to be infringing on an individual's charter rights, did you look at the least intrusive ways of accomplishing that government goal? And when we're talking about charter rights, of course, that's a key consideration because you're putting infringements on some pretty important issues, whether it be freedom of speech or what have you. If that were to be applied to a case of high-risk vendor equipment, for instance, everyone understands the government's policy about restricting high-risk vendor equipment. That would include Huawei or ZTE. That is one of the core considerations of an order in council stemming from this provision. In a context of a challenge, someone could ask, well, did you use the least intrusive means to accomplish this goal? Yes, you have an order saying that the companies must remove this equipment or cannot use this equipment, but that actually a less intrusive option would be to have a subsidy program and pay the businesses to remove that equipment. So it's hard to say definitively what would play out in a legal challenge environment. But given the case law around proportionate in a charter rights context, those are the risks we've identified.
Thank you. And on this proportionate question, there's been a lot of industry and business concern about the potential for, like companies being given wildly large fines or potentially very large penalties. And do you think that the inclusion of the word proportionate, maybe not so much from a legal standpoint, but from creating an assurance that, when the government does need to bring in an order to bring a business or an industry into line, that it's not going to be, it seems like if we remove the term proportionate, we're creating some uncertainty. And I'm wondering if you could comment, from the industry perspective, is there not a concern that if we don't include terms like proportionate, that we could be creating a lot of uncertainty in our economy?
Thank you, Mr. Chair, for the question. So certainly we're live to the concerns about industry. Under the Radio Communication Act, for instance, currently, we license spectrum and wireless usage. We have spectrum auctions that are hugely consequential and shape the industry and have big implications for businesses. We are already subject to a range of administrative law requirements as established by the Supreme Court. So we're well habituated to that. In this particular context as well, the addition of the reasonableness language makes that even further explicit in the bill itself. And the criteria as established by the Supreme Court for what makes for a reasonable decision includes principles of proportionality and the impact on the entity in question. I can pull up, I believe it's paragraphs 133 and 134 of the 2019 Vavilov decision, but it is entitled Impact on the Entity in Question. And it says very clearly, the gravity of the obligation on the regulated entity, on the person, needs to be reasonably linked with what you're trying to accomplish. And the more it is out of whack, the more that is likely to be determined an unreasonable decision and determined as invalid.
Ms. Michaud, please.
Merci, Monsieur le Président.
Thank you, Chair. I very much understand these explanations on this concept of proportionality. I just wonder whether if we remove that, would it not read in a rather strange way? In French, it would say the provision of the order must in scope and substance be reasonable to the gravity of the threat of interference. Reasonable to the gravity. I don't know if we can actually say that or if we need to add something, add in a word or two so that it flows freely. I'm looking to the law clerk. I think you've understood what I'm driving at. If it's fine for you, that's okay for me, but I just wanted to flag this. Yes, of course, we would have to ensure concordance as well.
Ms. O'Connell, please.
Thank you. I think the point has already been made, but I just wanted to summarize. The fact that it needs to be reasonable is one that I think the government's position is we accept, and that's precisely why it was added already in our G1 amendment. But proportionality in this concept, and even using, Mr. Arbor, your example, I would think that you mentioned a proportionality or the least restrictive, using your Huawei equipment example. One could argue least restrictive is just leave it as well. And so I would be concerned in leaving that door open rather than having the ability to still take assurances against, for example, equipment that might pose a risk or a gap in the system. And that I feel comfortable that leaving the language around reasonableness and what that then triggers in the law, I think accomplishes what stakeholders had certainly raised without getting us into a legal fight about proportionality using a charter standard when we're not talking about potentially people, we're talking about equipment within a system. And I think that we want to ensure reasonableness in terms of the order, but let's make sure that it doesn't handcuff us from actually achieving the security features that might be needed in, for example, telecommunications equipment.
Mr. Lloyd, please.
Just a very quick question for officials based on that. Is that a possibility that if the proportionate is in there, that it would not be to remove the equipment if it was that threat? Or would that not make the standard of the least restrictive? I mean, they have to do something. Is that a realistic possibility from what my Liberal colleague just said?
Thank you, Mr. Chair, for the question. It would, in any context like this, it will depend on the specific facts of the case. So the court would look at what are you trying to accomplish, what is the status quo, and what are the minimum requirement to establish that. It's difficult to comment on a hypothetical. I could imagine arguments being made that there's a natural equipment life cycle and that setting the requirements for the next generation of equipment and letting them life cycle them out could be another argument. Oh, pardon me. I'm a handsy talker. That is an argument in theory that could be made, but it would have to be grounded in the facts and the specifics of the case.
On the sub-amendment. Yep. All those in favor? On the sub-amendment?
A recorded vote?
Mr. O'Connell?
Yes.
Mr. Biddle?
Yes.
Mr. Gaillard?
Yes.
Mr. McKinnon? Yes. Mr. Shifke?
Oui.
Mr. Chaplin?
Yes.
Mr. Lloyd?
Abstain.
Mr. Matz?
Yes.
Mr. Correct?
Yes.
Madame Michaud?
En faveur.
Monsieur Julien?
Opposé.
9 yeas, 1 nays, and 1 absent.
Defeated.
Adopted.
Adopted. Carried. NDP 2. So we'll go to a vote. Sorry, Mr. Carrick.
Yeah, thanks, Chair. And most of my questions have been answered, but just to ensure on the record, the proportionate versus reasonableness, similar to the conversation we had surrounding G1. Just because proportionate isn't in the language, there is the expectation of proportionality if a charter circumstance were to arise, even if it's not understood in the context of a circumstance we may face today. Reasonableness language does include, if I'm interpreting properly your explanation from G1, it doesn't exclude that from in the charter, the possible charter implications of proportionality in the future. Do you agree with that? And if you'd have any further comment, I think it's been pretty clearly articulated, but just want to affirm that that is in fact the case.
Certainly. Thank you, Mr. Chair, for the question. Yes, would be my short answer, and the slightly longer answer would be to say, within reasonableness, the reasonableness standard is established by the Supreme Court. There are principles of proportionality that are established. So to the extent that, and it's crafted, the language used is specific to an administrative law context, which is what we're dealing with here. And were the government to issue an order that was not logically coherent with what was trying to be accomplished, it would be vulnerable to a challenge as being unreasonable. To the extent there is a concern about charter rights, separate from administrative law decisions, yes, the Oakes test and reasonable limits criteria, including proportionalities in the legal sense as opposed to just the common vernacular sense, would absolutely apply as well.
Shall NDP2 carry as amended? Carried. All those in favor? Thank you. Okay. BQ2. If BQ2 is moved, sorry, go ahead, Mr. Julian.
So CPC2, we set aside? Yeah.
Yep.
Thank you.
Okay.
Thank you, Mr. Chair. Just going at that right pace there.
If BQ2 is moved, CPC3 cannot be moved as they are identical.
Alors, je vais déposer l'amendement.
So I'll move this amendment. Thank you, Chair. As we know, this bill allows the government to make confidential orders that apply to telecommunications service providers, and there are situations where confidentiality can be justified, but it shouldn't be the rule by default. That's what we've heard from several civil liberties organisations. So we're proposing that there would need to be an order from the federal court. That would be one way of striking a balance against any excess of the government, and that would make sure that the government doesn't say that or is trying to cover up intrusive action. So this would give us some checks and balances in the bill, and I will read this out. The replacement on application by the minister, the federal court may, by order, prohibit any person from disclosing some or all of the order's contents if it is satisfied that there are reasonable grounds to believe that such disclosure could be injurious to international relations, national defence, or national security, or endanger the safety of any person. I was wondering about line 3 of the amendment where it says disclosing some or all of the order's contents. Perhaps it doesn't read well, but I think that the law clerks are the specialists when it comes to how we should express that and if it's drafted correctly from a legislative point of view. I just wanted to flag that. And I also have a question to put to the witnesses before we go ahead with the debate. I wanted to make sure that adding this amendment would not add in too many time delays in the overall process. Would that be the case or not? Would it drag things out, basically? Hope that's clear.
Merci, Monsieur le Président.
Thank you, Chair, for that question. So with this amendment, there would be some risks in terms of efficiency within certain contexts. Perhaps there would be a possibility of adding a few weeks if it was a case coming before the courts, and there are certain circumstances, for example, with solar wind back in 2020, where there was an attack on solar winds, which was providing software and equipment for a great deal of critical infrastructure sectors. So as a result of that, created basically a crisis situation and an emergency situation in order to try and resolve this. So if we impose this obligation of having to come before the court, the consequence is that there would be some risks if a similar situation were to arise in the future.
Ms. O'Connell, please.
Thank you. I think we share the concerns of just the time delay in a situation where there could be potential risk to the system or vulnerabilities, and adding the court process could add that delay, which we all know in a cyber threat could be significant. But keeping in mind that we agree with some of the concerns Madame Michaud and others have raised in terms of the accountability and transparency of when an order is made. So we have proposed in G 5.1 what we think might help address those legitimate concerns without slowing it down, which would require the notification of an order to NSECOP and NSERA of any order being made. This would allow both under the protections around confidentiality of national security information, but it would alert both groups to know in advance or know that an order was actually made, because I think we heard that the question would be, well, how would anyone even know if there was an order to look into it, to see as parliamentarians, to have that accountability. So we think this is we can't support this because of the delay, this particular amendment that we worry could add concerns and a potential risk, but we acknowledge kind of the overall concern about accountability and transparency, and we think referring or notifying NSECOP and NSERA of every time an order is made will allow for that reflection to be done. So that is, again, in G 5.1. So we can't support this as is, with the hopes that we can find that balance later on in that amendment.
Mr. Shipley, please.
This is a very pleasant day, Chair. We're agreeing with our friends across the table a lot today. We also will not be supporting this amendment. And just so everybody doesn't think we're trying to do something a little slippery, we will be withdrawing our similar amendment on CPC 3 once and if we get there.
PQ2, Carrie.
Est-ce qu'on peut avoir un vote par appel nominal, Monsieur le Président?
Could we have a recorded vote on that, please?
Mr. Biddle?
No.
Mr. Gay? Mr. McKinnon?
No.
Mr. Shifke?
No.
Mr. Shipley?
No.
Mr. Lloyd?
No.
Mr. Mutz?
No.
Mr. Kirk?
I'm opposed.
Madame Michaud?
En faveur.
Mr. Julian?
En faveur.
9 yeas.
Not doing this one, right?
2 nays. Sorry, 9 nays, 2 yeas.
So,
Okay.
so no need to remove
No,
CPC 3.
I just want to, Mr. Julian, we're passing by CPC 3, just to make sure. Sorry, Doug.
appreciate
Yeah,
that.
Mr. Shipley.
And,
Yeah.
so
It is withdrawn, right?
G2, someone needs to move it.
Okay. And G2, someone like to, Mr. Gahir?
Great, thank you, Chair. G2 edits Clause 2.1. This amendment adds a non-exhaustive list of factors that the GIC must consider prior to issuing an order. The list of factors would include the financial impact on telecommunications service providers, the operational impact on TSPs, the delivery of services to consumers, and anything else that the GIC deems relevant. I think this is something that we heard during testimony as well with witnesses. Obviously, the government will conduct a thorough assessment and look at the impact of the order on implicated parties. But some stakeholders raised the issue that, adding an explicit requirement within the bill itself, will go a ways. Thank you.
No. Shall G2 carry? All in favor? NDP 3. Pardon me? Yeah. If NDP 3 is adopted, CPC 4 cannot be moved due to a line conflict. Mr. Julian?
Thank you, Mr. Chair, and I apologize to my Conservative colleagues in advance for CPC 4 not being able to be moved if we adopt NDP 3. Again, we had a persistent theme in terms of the testimony before the committee that we need to ensure transparency around C26. And so what NDP 3 would accomplish is ensure that orders are published in the Canada Gazette within 90 days after the day on which it is made. This is something that has been suggested by coalition members who appeared before the committee and ensures more transparency for the bill.
Anyone? Mr. Shipley?
Thank you. I hate to say this to my good friend down the table here, but because he was so nice to us, but we will be voting against this amendment, and I know. And if this moves forward, we will also be withdrawing our next amendment, which is CPC 4.
Okay. Shall NDP carry? 3 carry? Did you want to? No. Oh, Ms. Michaud.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. This NDP amendment includes 90 days. What is the usual amount of days? Is 90 days enough? Should it be more than 90 days? Is there a common amount of time?
Merci, Monsieur le Président.
Thank you, Mr. Chair, for the question. It would not be an issue for us. For service providers to know their obligations, we need to publish the rules well in advance. And so 90 days would not be an issue.
Thank you. So I understand the statement you just made, Mr. Arbour, but I'm wondering, could it ever be an issue? Has it ever been an issue in the past? Because all we're trying to get at is a timely release of the information. I think that's what my NDP colleague was trying to do, is you need to put some parameters around the time with which it should be presented, right? So you say you have no problem doing that, which is great. What's the average general time that that matters get into the Gazette from the Public Safety Department?
Thank you, Mr. Chair, for the question. Just to clarify, I'll speak from ISED's Innovation, Science and Economic, of course. Generally, because parties need to know what the obligations are, we will coordinate the publication in line with when they're in effect. So there is a bit of a period of between when you submit the package to the Canada Gazette. It can be a week and a half before it is published, and we'll coordinate accordingly. But just to say that even allowing for some unexpected problem or something like that, 90 days allows for a quite comfortable period of time to get publication done.
So then, this is about the order. So once an order is made, you're saying that, you have no issue, achieving that 90 days, and even though the act doesn't specify a time, you're suggesting that you can easily do it within 90 days now, and it's just a matter of, so it's I guess my question more line was, so the Gazette's going to need a week to get it published, potentially. From the time an order is made until you give it to the Gazette to put in. Is that all, are we talking, within a week as well? Potentially, or two?
Thank you, Mr. Chair, for the question. So we will, how it works is that we coordinate for an order in council. There is a separate process going through the Privy Council office as well to get the Governor General approval on the final order. And we will coordinate that in line with the Canada Gazette process in parallel to make sure that things are presented appropriately publicly.
Thank you.
Thanks for that. So just to the way that I read line 12 in the act is that it must be published in the Canada Gazette. It doesn't speak to a timeline, but must be published. From your testimony, it sounds like there's an immediacy factor to that, and in some cases even in advance of the order taking effect. I'm just and the reason I bring that up is the tense to which you're describing the circumstances for something being gazetted versus a 90-day explicit timeline that's listed here. Would the 90-day timeline have the potential of actually reducing the requirement that it be done with industry and the timeliness that it speaks to in the current writing of line 12, which is section 4? I'm just curious if you can comment on that, because if you're doing it immediately, is that what the expectation is with the current wording versus you add 90 days? Does that create possible complications for maybe adding time that may not currently be the case with the way that it's written?
Thank you, Mr. Chair, for the question. No, I don't think it would contribute to delay to the publication of orders. The way that the current requirements are set up is that we would announce something and publish an unofficial version, such as on our website, and then would have to publish the full version in the Canada Gazette. We would have submitted that, and that would come a week and a half later. It's in our interest to have that out as quickly as possible. Adding a 90-day requirement neither delays it, but I can understand that if you didn't see a deadline specifically in the bill, there could be some concern that the government could drag its feet on this. So adding a specific deadline doesn't create problems for us, but I could understand why it might provide some additional comfort.
No. So do we require the conversation? Do we require a vote on this? All those in favor? No? Do you require a vote? Okay. Okay.
Division. On division.
That's
Are you on division? Okay. Thank you.
On division. Oh.
All right. So are we here?
So, no, because he's not moving it.
Okay.
So now we're NDP 4.
Okay.
And we got that.
Okay. So CPC 4, you're not moving it, Mr. Shipley. NDP 4, no, if NDP 4 is adopted, G3 and G4 cannot be moved due to a line conflict.
Thank you, Mr. Chair. Again, this is one of the recommendations from the coalition, concerned about the powers that are being given to the minister and ensuring that there is more guardrails around that to ensure that the legislation is effective. And so what this would do is amend in Clause 2, if there are reasonable grounds to believe that it is necessary to, and replacing on page 3, specified in the order in the respect of which there are reasonable grounds to believe it is necessary. So this is part of what I think we're all endeavoring to do, to provide more guardrails for the legislation to ensure transparency and accountability.
Thank you. I just wanted to say we agree with this and are supportive. As in G1, we acknowledge and accept that adding additional language in the legislation to reiterate the reasonable grounds is something we're supportive of. I don't think it was any intention to be left out. It was kind of assumed, but any opportunity to put in and clarify, we are supportive of this.
Mr. Shipley, please.
Thank you. Just wanted to let my friend down at the end of the table know, because we've been going against him on a few here. We will also be supporting this amendment.
Mr. Motz, please.
Well, I have to say, while I agree with the intent behind this, the language in G3 is in line with how the Act reads generally. Because the language, as it's written in NDP 4, says it to me in a backwards fashion. If the minister believes on reasonable proper grounds that it's necessary, would be, to me, a proper way to put it, because it falls in line with the way the wording is in the Act for other type of language. That's all I'm suggesting. It says the same thing, only one says it one way and one says it in an NDP backwards sort of way.
And Glenn wants it his way.
You meant NDP forwards kind of way.
But it's not a hill I'm willing to die on either way. Just wanted to point it out.
Shall NDP 4 carry? All in favor? Okay.
Unanimously.
Okay.
Unanimously.
Moving on to G3, can only be, no, sorry. G3, yeah. G3.1 can only be moved if BQ1 was defeated. Also, if G3.1 is adopted, BQ3 and CPC 5 cannot be moved due to a line conflict. Mr. Gare.
Thank you, Chair. This is just coordinating with G 1.1, which is the committee did agree with. And we're just saying that Bill C-26 in Clause 2 be amended by replacing lines 25 and 26 on page 2 with the following. Against any threat, including that of interference, manipulation, disruption, or degradation, the minister may, by order of, and so it goes on. Thank you.
Thank you, Mr. Gahir. Yeah. I'll give you a second. You okay? You good? Good. No one else? Shall G 3.1 carry? All in favor? Okay, BQ3.
So 3 comments, no, so PQ no cannot be moved because of the...
Right.
So cannot be moved.
CP5,
CPC
G
5 also is
3.2,
down.
yeah.
Yeah, so we go to
G 3.2 can only be moved if BQ3 and CPC 5 were defeated.
So we need to move it.
Need a mover? Mr. Gahir? Sorry?
You say that again a little more slowly, Mr. Chair?
G 3.2
Yeah.
Can go ahead, what's that? It's already obsolete. It's basically obsolete, but can only be moved if BQ 3 and CPC 5 were defeated, which
So they were not moved, so.
they were not moved.
Great. Thank you, Chair. So this is G 3.2.
Yeah, you guys just hang on one second, just to make sure we're all caught up. No. Yeah. See that? Good? You okay, Mr. Julian? Good. Mr. Gahir, please.
Great. Thank you, Chair. So we're on G 3.2.
Yes.
This is similar to G 1.2. We are concerned about being too prescriptive and limiting the ability to consult with required people as threats. Obviously, when we look at administrative law, there's a zone of expertise that we allow the agencies to have. So the amendment is that Bill C-26 in Clause 2 be amended by replacing line 28 on page 2 with the following. And I assume it's like Minister of Emergency Preparedness, and with the persons the minister considers appropriate.
Mr. Lloyd, it's the first one.
Thank you, Mr. Chair. This has always somewhat confused me because we do have a Minister of Public Safety and a Minister of Emergency Preparedness. However, all of the legislation that gives the Minister of Public Safety power references him or her as being the Minister of Public Safety and Emergency Preparedness. And so I was just a bit confused by Mr. Gahir's. Are we suggesting that this legislation is going to fall under just the Minister of Emergency Preparedness, or is this falling under the Minister of Public Safety and Emergency Preparedness, which, I mean, is technically two ministers, but in law, it's actually under one ministry? Officials have anything to say about that?
Thank you, Mr. Chair, for the question. So in legislation, we are required to use the legal name of the minister in question. So, for instance, you'll see a lot of references to the Minister of Industry and not the Minister of Industry, Science and Innovation, even though that is currently the name currently styled. So the reference speaks to the legal name of the minister in the underlying enabling legislation for the department in question.
Mr. Lloyd, please.
Yeah, so to clarify, I was just a bit confused by what Mr. Gahir said. This is going under the Minister of Public Safety, not the Minister of Emergency Preparedness.
Thank you, Mr. Chair, for the question. Yes, that's correct.
You good? Good? Shall G 3.2 carry? Yes. All in favor? G4? Next one?
G4, no, because.
We carried that, so we're moving down.
G4, yeah.
Okay. G4.1. Right.
Yeah, don't need to read that.
Okay. G4.1. If G4.1 is adopted, G4.2, 4.3, and CPC 6 cannot be moved due to a line conflict. Move it. Mr. Gahir?
7 then? No.
G4.1.
Great. Thank you, Chair. So we're on G 4.1. This is coordinating with G1 to add degradation to the enumerated lists. Yes.
Discussion. Good. Good. Shall G 4.1 carry? All in favor? Okay, 4.2.
4.2, and you read
Just
also.
start here.
Yeah, yeah.
C6 are then moot?
Right.
4.1, yeah, CPC 6.
So 4.2, 4.3, and CPC 6 are
cannot
toast.
be moved.
Just a second, just make sure.
Yeah, he's just moving a second. He's just making sure. 4.2, 4.3, and CPC 6 because of line conflicts, and we're on to CPC 7. Take your time. You're withdrawing it? Okay, withdrawn. So we'll go to NDP 5.
Yeah, so ask him if he wants to move it.
NDP 5, Mr. Julian?
You're just going at a breakneck speed here, Mr. Chair. I'm getting paper cuts now from moving through the clauses. So NDP 5 is very similar to NDP 2. Some colleagues around the table may want to delete proportionate, given that we have done that previously. Not that I agree with that, but I certainly understand the consistency. What NDP 5 would be, again, this comes from coalition recommendations. It would amend on page 4, after line 12, the provisions of the order made under subsection 1 or 2 must, in scope and substance, be reasonable and proportionate to the gravity of the threat of interference, manipulation, or disruption.
Further discussion?
And removing proportionate.
Yeah.
Sorry. Yeah.
Thank you. Sorry. We just, once again, we have no issue if you want to add in degradation to keep it consistent. But again, our objection to proportionality is simply the legal term. So if it's a question of removing, amending, sub-amending and removing that, we're willing, or we would have to vote against the amendment. So I will move a sub-amendment to remove, after be reasonable, remove and proportionate, and then add after manipulation or disruption and degradation.
A disruption or degradation. Yeah.
The same consistency as before.
Yep. Vote on the sub. You in favor with the sub?
All in favor of the sub-amendment?
Yeah.
Mr. Julian? Yeah. Oh,
Just a second.
Opposed in principle, but
Okay.
understand the reason why it's being
Okay.
proposed.
just hang on. The officials just hang on a second.
Oh, okay, I'll do
You
it.
good?
Perfect. Okay, yeah.
So we're good. Okay.
So on the sub-amendment.
Right. That was a sub-amendment. Back to the amendment.
So the sub-amendment carried?
Carried.
Okay,
Yes,
thanks.
sorry. Yep. Good. Shall NDP 5 carry?
As amended.
Yep.
As amended.
As amended. Shall NDP 5 carry as amended?
Yes.
All those in favor? Good. Good. BQ4, please.
Oui, merci, Monsieur le Président. Alors, ça peut apparaître.
Thank you, Mr. Chair. It might seem a little strange as an amendment, but I will explain it. It seemed to be a good opportunity to add this to the bill where the minister can order that telecommunications service provider have a backup system to ensure the security when there is a risk of interference or manipulation or disruption. It could ensure that there would be a system to power telephone towers. For example, Terrebonne and other cities are in a similar situation. When there is strong wind or storms and cell coverage is down because of the towers don't have a backup system, that is an issue. And if there's a cyber attack, it would allow a backup system to power telephone towers. I hope that colleagues will vote in favor of this amendment that could make a difference in the lives of many people. Thank you.
Good. Question?
Could the officials explain to us or tell us how practical this is? I understand the importance of it, but is this something that's in the industry now? and the impact of this compared to what's common practice?
Thank you, Mr. Chair, for the question. Yes, considerations around backup power are an important consideration in the industry currently. And there'll be different systems of backup power at different parts of the network. One thing that I would flag is, while I understand the objective of the text, it could have a risk of accidentally limiting the government's authority, just because there are other parts of the telecommunications network that require backup systems or backup power. So backup power to fiber optic cables can be an issue, for instance.
So you're saying that by limiting it to towers, we might create a problem, even though the idea is, can we just add telecommunications systems?
Thank you, Mr. Chair, for the question. Removing the reference to power, so it's backup systems more broadly, and making reference to telecommunications facilities as opposed to just towers would solve that issue.
O'Connell, please.
Thank you. On the same point, actually, and I think the intention is we all agree with, but I'm going to move a sub-amendment just to kind of clarify that language, that it require that telecommunications service providers use a backup system for telecommunications facilities. I can hand you my paper quickly. And again, it's just, the intention is there, it's just cleaning it up so that it's not limited just to towers and power. That it's for backup systems for telecommunications facilities, so it would encompass everything.
Okay. Shall BQ4 carry as amended? All in favor? Okay. Good?
Yeah.
Okay. G4.4, Mr. Gear.
Thank you, Chair. So this amendment is in regards to concerns from civil liberties groups that the bill could be used to target individuals. This makes it clear that the bill is from dealing with network security and it's not for intercepting communications. And I'll just read the language of it as well, actually. It's 2.1. For greater certainty, despite subsection 2, the minister is not permitted to order a telecommunications service provider to intercept a private communication or a radio-based telephone communication, comma, as those terms are defined in section 183 of the Criminal Code.
Any discussion? None? Shall G4.4 carry? All in favor? You're really rushing me now. Okay. You good?
Yeah.
Thanks. BQ5. If BQ5 is adopted, CPC 8 cannot be moved due to a line conflict. Ms. Michaud.
Merci, Monsieur le Président. Alors, BQ5 qui est...
Thank you, Mr. Chair. BQ5 is an amendment similar to BQ1, I believe. It was a way to balance out the ministerial power. We heard from different organizations on this, including those protecting civil rights.
Mr. Shipley, please.
We will be voting against this amendment, but also withdrawing our CPC 8, which is similar.
Okay. Ms. O'Connell?
I'll just quickly reiterate that I think the intentions, we agree in the sense that we want to create some oversight and accountability, but we worry this language could add unforeseen delays in the ability to act quickly, and that we are hopeful that our amendment later, which I think was G 5.1, will address some of the abilities to have that oversight and review, but in a national security context. So we can't support this just given the timelines and delay, but we do understand the intention.
Toutes mes excuses, Monsieur le Président.
Apologies, Mr. Chair. It was not rather, it was similar to what I had proposed earlier, so that there would be a review with the federal court, but we seem to already have voted against that, so I understand my colleague's position.
Okay. Any other discussion? Shall BQ 5 carry? All in favor? No. Okay.
Mr. Chair, so it was defeated?
Yes.
Okay.
Yeah.
Okay.
Defeated.
That's helpful.
Mr. Chair, point of order.
Yes, Mr. McKinnon.
So I'm not in the room and I miss a lot of the nuance of what's going on. So it'd be most helpful to me to follow along on the many papers I have here if you recite back the outcome of a vote on a particular amendment and sub-amendment.
Thank you, Mr. McKinnon. CPC 8?
I think he's going to move it, so we are at
G5. G5. Mr. Gahir, please.
Thank you, Chair. This is similar to G2, actually, which the committee already voted on and accepted. G2 looked at the non-exhaustive list of factors that the GIC should consider, and now G5 is adding a non-exhaustive list of factors that the minister must consider prior to issuing an order. The list of factors would include the financial impact on TSBs, the operational impact on TSBs, the delivery of services to consumers, and anything else the minister will deem relevant. And this was, again, raised by civil liberties associations.
Discussion? Shall G5 carry? Yes. All in favor? Thank you. Carried. Carried. Good. After this one, we're going to take a short, I'll suspend for 10 or 15 minutes so everybody can get a bite and use the washroom. That's okay. NDP 6 can only be moved if, no, never mind. NDP 6. Mr. Julian, please.
Thank you very much, Mr. Chair. This is similar to NDP 3. What this would do is amend replacing line 19 on page 4 with the following, and we've already had this discussion, and the coalition, of course, was very clear about ensuring that there is transparency around this legislation. And one of the ways to do that is ensure that the orders actually appear in the Canada Gazette. So this would oblige the minister to publish in the Canada Gazette within 90 days after the day that day of which an order is made. And so in the interest of transparency, I move NDP 6.
Shall NDP 6 carry? All in favor? Carried. We're going to suspend for 15 minutes. meeting to order. Mr. Couric, please.
Thanks, Chair, and appreciate the opportunity, and I'm glad that we've been able to have a productive meeting thus far. I would, however, like to hopefully take just a brief few minutes to move the motion that I gave notice of this past Friday, and I'll read that motion and move it here shortly. But I would simply say this in the context for this motion, and one of the conversations that I know my Conservative colleagues, and I would suggest as well, my colleagues from other parties are hearing in relation to the very, very live conversation about the carbon tax. And the reason why I am moving this motion today is because in just a few, about a week and a half, 12 or so days, there will be a 23% increase to the Liberal NDP carbon tax that is driving up the cost of everything across our country, costing Canadians significantly, and both in terms of the tax that they pay directly, but also the significant impact that the carbon tax has across the entire supply chain, from the farmer who grows the food to the trucker who ships the food to every single person who does almost anything in the economy, Chair, is impacted by the carbon tax. And what has been so frustrating, and I heard this, I did a series of town halls across my constituency and spoke to some folks across the country, including some Canadians from constituencies that are represented by other members represented by members from other political parties, is that the carbon tax truly is having a devastating impact on the ability for Canadians to make ends meet. And the specifics of the motion that I'm going to read into the record here shortly, in relation to that 23%, talks about some of the additional costs that Canadians ultimately pay for. And I think that's a key part of the discussion that I know we do not hear an acknowledgement from the government and those who support the carbon tax, but that is the specific costs associated with the carbon tax when it comes to the budgets of the RCMP and other police forces across the country. Mr. Chair, Canada is a cold country. It was snowing here in Ottawa today. I know there's snow forecast in Alberta tonight and tomorrow, and while we certainly will enjoy and appreciate the moisture that snow brings, it's those freezing temperatures that require everything to be heated, and that includes the many local detachments, whether that be the many RCMP detachments in the rural communities that I represent, rural and remote across Canada, where the RCMP are working diligently to patrol, or the Camrose Police Service, the only municipal police force that I have in my constituency outside of bylaw enforcement and whatnot. But also the impacts that the carbon tax has on the increased costs associated with the ability for this essential service in our country to do their work. That's not to mention as well, Canada's a big country, and the RCMP reference when it comes to their work policing rural Alberta is, of course, the French acronym for the RCMP is GRC. And local Mounties have joked with me saying that's short for Gravel Road Cop. And the reason why I bring that up is because many Canadians see, and I'm sure many have experienced, the police force behind the wheel of their cruiser. And, Mr. Chair, the impact of that is substantial when it comes to the costs that our police forces have to pay, and that is tax revenue that goes to government that is not going to other public safety measures, and especially as crime and chaos seem to rule our streets, and I certainly heard a lot about that over the last number of weeks back in the constituency. But it also is that unwillingness for there to be an acknowledgement that this has an ultimate impact on the affordability of Canadians. So, Mr. Chair, I hope that we can find support to get answers, which is the first part of this motion, and to ensure that Canadians know that their parliamentarians, and I would hope from all parties, although I have my doubts, I would hope that we have that we have support to ensure that we can get answers first and that it is time to spike the hike and axe the tax to bring home lower prices for everybody. So, Mr. Chair, I would move the notice of motion that I gave on March 15th that says the following, that given the April 1st carbon tax hike, and I would just mention this has been distributed to committee members in both official languages. The motion reads as follows, that given the April 1st carbon tax hike, the committee call on the Minister of Public Safety and the Minister of the Environment to provide a report to the committee in 30 days on the additional costs the carbon tax adds to the RCMP budgets and police forces across the country, and to work with their provincial counterparts to ensure to secure this information and report it to the House in its recommendation to spike the hike and axe the tax. Look forward to what I hope will be unanimous support for a common sense motion brought forward today from Canada's Conservatives on this committee. Thank you.
Thank you, Mr. Couric. Mr. McKinnon, please, online.
Thank you, Mr. Chair. I move that the debate do now adjourn.
So moved. Good. Record a vote.
Ms. O'Connell.
Yes.
Mr. Biddle. Yes. Mr. Gay.
Yes.
Mr. McKinnon.
Yes.
Mr. Shifke.
Oui.
Mr. Shipley.
No.
Mr. Lloyd.
Name.
Mr. Motz.
No.
Mr. Couric.
No.
Madame Michaud.
En faveur.
Monsieur Julian.
Oui.
So, yes.
It's defeated.
Carried,
sorry. Carried. Carried. Yeah, Mr. Julian, please.
Just thank you, Mr. Chair. Conservatives did agree to go through C-26 without filibustering, so I just hope Mr. Couric now has a copy of that memo.
Thank you, Mr.
Because
Julian.
we really need to get through this bill.
Thank you. So we're moving right back into clause by clause. CP 8.1. CPC 8.1, sorry.
Thank you, Chair. We'll be moving that. Just took a moment after dinner break there. We will be moving that amendment. This is an amendment that was recommended by Citizen Lab. This amendment would require the minister to prepare a report stating the number of times an order prevailed over a decision of the CRTC made under this act, and that be tabled in Parliament. Hopefully we have support for this. Thank you.
No questions? Shall CPC, oh, sorry, Ms. O'Connell?
Thanks, Chair. Two officials, actually. I wondered, because this is, if this passed, this would require the submission of a report separate from one that's already proposed in NDP 7, BQ 6, and CPC 9. So I'm just wondering if it would make sense to not move forward on this and rather in the future amendments that come out in terms of reporting to just have one combined report? Or could you maybe elaborate or speak to if you see this as an issue or not, if a standalone report in addition to those others?
Thank you, Mr. Chair, for the question. This speaks to a separate clause that notes the possibility of an inconsistency between a government order and a CRTC decision, and is, for greater certainty, removes some risk that there would be confusion in the event of said inconsistency. Certainly, reporting on, to the extent this occurs, it doesn't present any operational challenges. Having it as a separate standalone report and with potentially some different timelines, there's actually potentially a bit of ambiguity in the language here. This doesn't present any big challenges or anything like that, but to the extent it was folded into one clearer annual reporting requirement would be a bit cleaner.
So thank you, Chair. So I think then, again, our issue is not with the intention, but I think it would be I'm not going to support this amendment only because I think we can take the intention and deal with it as one overall report that we have coming up in the subsequent amendments. Well, there's NDP 7, which would be next, BQ 6, and CPC 9 that also deal with reporting. And so again, it would be cleaner to just include, to have one report to talk about whenever orders were issued, et cetera, or prevailed over a CRTC decision.
Chair. Yeah, Chair, perhaps if there's good intent on that and seeing that the other side does want to have this in, we will withdraw that and we'll try to add that in the next NDP 7. Ms. O'Connell, is that what you're suggesting? Yeah. We'll withdraw ours then and we'll roll it in.
Consent to withdraw? 8.1, good. Mr. Julian?
Caught me at a bad time, Mr. Chair.
It's okay.
We're moving on to NDP 7.
We are, Mr. Julian.
A recommendation from the coalition and the coalition brief. You'll find it on page 16. And just to remind folks, it includes Canadian Civil Liberties Association, Open Media, Ligue des Droits et Libertés, Privacy and Access Council of Canada, and a number of other distinguished Canadians. So what they are looking for, what they proposed in their testimony was that there should be reports filed that pertaining to orders and regulations as a way of ensuring complete transparency. So there would be a requirement to file an annual report, and if the minister fails to file such a report, the minister would be required to come before a parliamentary committee to explain why that has not happened. And so those are the provisions that are with, I won't read it out because it's fairly lengthy, but the provisions of NDP 7. So move.
Ms. O'Connell, please.
Thank you. Because I just identified that we're open to the language from the Conservatives' amendment before, I won't sub-amend yet. I'll let them introduce theirs, but I will just say we're comfortable with this. We just have some concerns in section E and F, and we'd prefer to replace the number of with description of compliance. So again, I'll do that, but in fairness to my colleagues, I'll let them have the chance to move their amendment.
Sorry, what word did you want changed?
Okay, so if you go to section E of the NDP amendment, 2E, sorry, thank you. 2E, it says the number of telecommunication service providers that partially complied with an order. And F is the same. It says the number of telecommunications providers that fully complied with an order. We would like to replace the number with description of compliance. No, it's just in each one, replace the number with description of compliance.
You're okay with us chatting, so we're not going to do the sub-amendment yet, so we don't get...
Yeah, I haven't moved to some amendment yet.
We were looking at is by just adding an H, Ms. O'Connell, and it would be basically the paragraph under our CPC 8.1 of the 6.1. We would just move that as the sub-amendment, if that's making any sense.
It would be H3, isn't it?
No, it would be FGH.
What's FG?
Oh.
FG3.
Or it could be 3.
No, I understand what you're saying.
Do you want it as 3 or H? Just adding it as an extra paragraph?
I'm just wondering those if that's
Saying
only
it should be
dealing
three,
with
not H.
the number of times an order was made under and prevailed over a decision, or if it's the number of time, I guess it's or. Could we potentially park this one and work on some language to get consistency in terms of what you want to add, and then we can see if it still complies, unless everybody else wants to move forward. But I think it would make some sense for us to come together on this one.
Yeah, I think there's some agreement. We want to see something in here, so I agree. Let's park this if that's the will of the committee. And I agree with what my other colleague said. It would be better if we go with our extra paragraph to make it a paragraph 3 by adding the 8.1. But we can. I'm fine with parking it too, Mr. O'Connell.
So, recommendation from. To do right now, I'm told, is suspend for maybe 5 minutes and we'll get this straightened out because it may have effects on other parts of the. All right? Okay?
Do you understand what we're trying to do?
Maybe in writing, it would also help us. Okay.
We have it right.
So we're suspended for 5 minutes? Reconvene, please. Okay. Mr. Shipley, please, if you want to read the.
And I do apologize, that took a little bit longer, but sometimes that's the way it goes. I think we've got a good compromise here now. So this will be, our amendment or sub-amendment? Sub-amendment. Our sub-amendment, we will add it as a paragraph 3, and we will state, the report shall state the number of times that an order prevailed over a decision of the Commission made under this Act during the previous fiscal year, and must cause the report to be tabled before each House of Parliament on any of the first 15 days on which the House is sitting after the report is completed. Sorry? No, Jen's doing those. They have to be done separate.
Okay.
Right, Jen? You're doing those? Yeah. That's it. Yeah.
There's vote on it, then do ours.
So you're not, okay. Did you guys, you good? Okay, so we call for a vote?
Yep, all in favor.
Yeah.
All in favor? Mr. Julian? Okay. Okay, so we're going to move on to the second
Amendment.
Pardon?
Go back to the amendment.
Yeah. Just one moment, please. Well, she is. Line, we actually have 2 amendments, sub-amendments. We're dealing with the second one now, if you missed that.
I'm sorry, I wouldn't know.
Connell, please.
Thank you, Chair. We're just sorting out the French translation, so I think the law clerk can help with that, because you wouldn't want me to try and make that attempt. I'd make it probably worse. But my sub-amendment, as I've kind of stated, was to be on 2E. I'll start with that one. 2E, to change the number of to description of compliance. And then into F, very similar, to replace the number of with description of compliance.
Partial. Compliance, is it not? And E should not be partial compliance?
Nope, because the first one
Never
is,
mind.
sorry, in E,
Yep.
yeah, it's just the 2 types of compliance.
Yeah, thank you.
And we do have the French translation if there's questions.
Discussion? We call for a vote? All in favor? Sub-amendments carried. Back to the original motion? Okay. So we're back to the original NDP 7. Shall NDP 7 carry as amended? All in favor? Thank you. Whew. Moving on. BQ 6. No? Oh, sorry. CPC 9. CPC 9, sorry. Is that carried too?
Because it's the same.
So-
BQ 6 was the same, then you go to CPC 9, yes.
Yeah, CPC 9, yeah.
Moving that amendment. And CPC,
It's the same as NDP 7.
oh,
That's the one we just fixed. Yeah, so we're drawing that one. So because NDP 7 was passed as
oh, it's
amended.
the same?
Block 6 and CPC 7.
Oh, sorry, pardon me. Well, we were
Yeah,
doing that.
just hang on.
Sorry.
It's my fault. 5.1.
Great, thank you, Chair. This is just adding an NSECOP and SERA reporting requirement. There's a cleared group of individuals here that will be given transparency. It doesn't require that they act on the information, and therefore it doesn't interfere with their work either. Thank you.
Any further discussion? Shall G 5.1 carry? All those in favor? Good. NDP 8? If NDP 8 is moved, CPC 10 cannot be moved as they are identical.
That's scary.
Mr. Julian?
And this is going to be, I think, one of these key decision points today in terms of the legislation. What was clear from testimony that we heard from a number of sources is that the Statutory Instruments Act, that the Cybersecurity Protection Act needs to be under the Statutory Instruments Act in terms of transparency, in terms of the overall accountability of this legislation. There are a number of amendments that we are offering that basically have as an objective ensuring that the Statutory Instruments Act does apply. And this is something that has come as a recommendation from numerous sources in front of testimony that we heard. We have a number of amendments coming forward as we debate this bill. This is the first one. But that the Statutory Instruments Act apply, that it be accessible for regulations. The Standing Joint Committee for the Scrutiny of Regulations is something that we believe is important, and that is why in following up on the testimony that we heard that clearly indicated for transparency that this is an important component, I am moving NDP 8.
Thank you. Ms. O'Connell, please.
Thank you, Chair. We do have some concerns with this. We think it adding the SIA becomes too broad and can add up to 18 months of regulatory processes on it. So I guess, though, I just want to make sure I'm clear and all committee members can directly understand what this amendment would mean. So my questions to officials, I'm curious about what this amendment, if passed to the legislation, if 18 months are added to a regulatory process, what damage could be done in that time frame, and what concerns about the network, like harms to the network, could be done in that time frame. And then a second question on that is, does this have impacts then with our national security and our relationships with other allies like the U.S., who we have an interconnected grid? Because it's not just telecommunications, and that's what we have to remember. So perhaps officials can kind of add some context to what harms, probably unintended, that could come in adding this amendment.
Thank you, Mr. Chair, for the question. So I certainly, having followed the testimony, appreciate the sentiment behind the amendment. There are maybe three categories of practical considerations that would pose challenges from an implementation standpoint. The first is that the overall structure of the SIA and associated regulatory policy goes with it. Has challenges in a technological space and a national security space. So the range of incidents that can arise quickly, or that can evolve over time. In particular, as more and more of our network is handled in software. So with 5G, for instance, a lot of the key functions are handled in a software patch up that can move very quickly. There are incidents such as, I mentioned the SolarWinds incident, where this was a vendor that provided critical infrastructure subsystems to a range of different sectors. They themselves were compromised, which had spillovers all across different sectors. The Colonial Pipeline incident with ransomware is another case where a ransomware incident for an oil distribution pipeline had huge impacts all across the eastern seaboard. So adding long stretches of delay throughout that process has real tangible issues from an implementation standpoint. A second thing, the exacerbating factor, is that the underlying legislation that we're dealing with is not subject to the SIA currently for the main activities. So this would be quite a large departure from the way that regulation under the Telecommunications Act and the Radio Communication Act is currently done. And so that would have further compounding effects. The third category of considerations here is that the structure of the Act was developed with the conception that the SIA would not apply. So there are certain structures within the Act to address the lack of the SIA applying. So for instance, there are specific provisions around publication in the Canada Gazette and dealing with confidential orders. There are parallel provisions in the SIA. If we're going to have those parallel structures within this Act, elaborated upon with some of the amendments this evening, and then reimpose in the SIA, we'll have some further parallel considerations. So I appreciate the intent behind it, but those are the practical considerations.
So then, thank you, Chair. Just following up on the two real-world examples that you listed, what then, assuming this legislation was in place and this amendment with the SIA now being required, what would that have meant in those two examples, whether, or you can choose one just for the sake of committee discussion, but 18 months of, potentially 18 months, correct? Like, what specifically would this do in those real-world examples? Is it just the time delay, or are there other regulatory processes that would essentially make this legislation, like, what's the point of it if after 18 months you're dealing with a ransomware or a cyber attack? At that point, this becomes, I think, obsolete.
Thank you, Mr. Chair, for the question. Certainly, there would be real-world consequences that would make it hard to keep pace with the developments of technology and the sector. That is one of the considerations in the current regulatory sphere that we're dealing with, where the SAA does not come into play in regulating under the Telecom Act and the Radiocom Act. This would have implications for urgent situations where we'd be working around that, but also important circumstances like dealing with high-risk vendor equipment, which does not necessarily have an emergency context, but does have real-world considerations in dealing with our allies and coordinating continental security, telecommunications infrastructure.
Okay, thank you.
Motts, please.
Pass, thank you. I got my question answered.
Okay, thank you. Mr. Shipley?
Thank you. Just to maybe speed this up a little bit, we will not be able to support this, and we will be withdrawing our amendment next that is similar.
Okay. Mr. Julian, any further comments on this, or?
Just an urging members of the committee to pass this. This is something that came up repeatedly in testimony before the committee.
Okay. Move to a vote. Move to a vote. All in favor?
Ask for a recorded vote.
Ms. O'Connell,
No.
Mr. Biddle,
No.
Mr. Gair,
Nope.
Mr. McKinnon,
No.
Monsieur Chiffrier,
No.
Mr. Shipley,
No.
Mr. Lloyd,
Nay.
Mr. Couric,
Opposed.
Mr. Matz,
No.
Madame Michaud,
Contre.
Mr. Julian,
En faveur.
1 yeas,
Defeated.
10 nays.
Defeated. We're now moving to BQ7. If BQ7 is moved, CPC 11 cannot be moved as they are identical.
Merci, Monsieur le Président. Alors, BQ7.
Thank you, Mr. Chair. BQ7 pertains to the time that information is kept. We heard from different organizations that the bill should be amended so that any information collected or obtained under this act must be retained only for as long as is necessary to make, amend, or revoke an order under Section 15.1 or 15.2 or a regulation under paragraph 15.81a, or to verify compliance or prevent noncompliance with such an order or regulation. The period necessary for the purposes set must be communicated. We are proposing that if there are agreements with foreign organizations, those amendments can be made, and so it's a bit of a guardrail that for organizations that had issues with information that was gathered and how long that information was kept for. Thank you.
Anyone else?
Mr.
Yes.
Shipley. Mr. Shipley.
Mr. Shipley first, please. Ms. O'Connell.
Thank you. We will not be supporting this, and for transparency, we will be withdrawing CPC 11 after, if necessary.
Okay. Ms. O'Connell?
Thank you, Chair. Well, we agree with the intention in terms of privacy and privacy rights, and we understand the concerns raised by witnesses. We just think for clarity, because although kind of in essence the amendment itself, it's again the intention we're okay with, but we feel that it's a little unclear in the language, and we actually prefer Government 6.1, which reiterates that the Privacy Act would supersede the provisions in this bill, to give that level of assurance, because we did hear that it was silent. We just think it's clear and adds that certainty that the Privacy Act would be the act that this bill would also have to comply with. We just think it's a cleaner way of achieving the same things. So we won't support this language as is, but just the intention we understand and agree, and that's why we have G 6.1 that comes up later.
Call for a vote? All in favor? Show of hands. Shall BQ7 carry? No. Defeated. So we're missing CPC 11, BQ 8. BQ 8. If BQ 8 is moved, CPC 12 cannot be moved as they are identical.
Merci, Monsieur le Président. Alors, pour BQ8, c'est un peu dans le même sens.
For BQ8, we want to add definitions that could be applied at D, for personal information or de-identified information. That was a recommendation from the coalition and from, as mentioned, Mr. Julian. They seek to protect Canadians.
Please.
Just very quickly, letting the block know down there, we will be supporting this amendment.
We just have a sub-amendment. We'd like to sub-amend D and replace or with and for greater clarity. So it'll be personal information and de-identified information.
Discussion on the sub-amendment? All in favor? Carried. So BQ 8 carry as amended? Yes. All in favor, good. Carried. CP 12? No, 12.1.
12.1.
Yeah. CBC 12.1 can only be moved. That's good. Yeah, we already got that. CPC 12.1.
Thank you. We will be moving 12.1. This amendment would ensure that information collected must be treated as confidential and only disclosed if it is necessary to secure the Canadian telecommunications system.
Any discussion? No discussion? Ms. O'Connell?
So I'm just making sure I'm on the right one. I think our concerns with this one were that, again, it's a timing issue, that it would require a court order to be sought prior to the release of the information. Maybe I'll turn to officials to see if I'm understanding this correctly. Do you see this amendment, through the chair, do you see this amendment as adding that requirement through a court order that would cause additional delay?
Thank you, Mr. Chair, for the question. Yes. So in the context of making an order, in certain circumstances where we are dealing with an emergency situation, that could include, in the process of making the order, divulging certain information that had been designated as confidential by a telecommunications service provider. This amendment would require getting a court order before that order could be made disclosing that information. I would flag that the information could only be disclosed if doing so would protect the Canadian telecommunications system. So it would only be possible in certain very limited circumstances. Thank you.
Okay, sorry, can I just hone in on that a little bit? Are you saying in other provisions within the Act clarifies when that disclosure can be made, right? And then so that's why with this piece, if the disclosure was to be made, you would have to seek a court order, which if you're disclosing the information, I would think that's a pretty big threshold. It's probably under an emergency type situation, and this would delay that. Am I understanding your kind of rationale there?
Yes, that is correct. So the possibility to disclose confidential information is quite narrowly constrained, but in the circumstances where that would be an issue would be to protect the Canadian telecommunications system, and this would add a requirement to go to court first.
Okay, thank you. Given that explanation, I understand the intention. I just think the issues around disclosure of information is covered in other sections of where that would be appropriate, and adding a court order delay raises concerns given the nature of what would potentially be dealing with would be cyber attacks and the speed of which we need to address those. I think everyone understands. So can't support this as is, just given that delay, but understand the intention.
Thank you. Mr. Shipley, please.
Thank you. Obviously, we want to make sure things are expedient to get dealt with. I'm just curious. I know this could be a tough one to give you, or to give you as a question to get an answer back. Obtaining a court order, if necessary. Can you give me a timeline on an instance like this that would be pertinent? How long that would take? Is there any idea?
Thank you, Mr. Chair, for the question. As you may have surmised in your question, it can be very context specific. However, another reason why it can be challenging to answer is that it depends, and it can depend on what the court is dealing with and broader contextual factors. But it could add days or weeks, depending on the context.
All right, thank you. I know my friend Mr. Motz has a strong, long-time law background. I'm going to see what he has to say about this. Not legal, but
Well, more
policing.
practical in my application of the law. That's what it is. Not theoretical like the
Practical is
lawyers.
good.
Thank you, Chair. So, I mean, in context, this is subsection 3, and it's talking about exceptions. So, information that is designated as confidential may be disclosed or be permitted to be disclosed if, and then A provides A, if it's authorized by law, B, the person who designated the information as confidential consents to its disclosure, C, the disclosure is necessary, in the minister's opinion, and then what we're adding is, the disclosure is authorized by an order made under Section 4. So we're changing C, right? Unless our numbers are wrong, we're not adding this as a D, we're replacing C with this, correct? That's how I understand it. So I don't know where the caution would be, because this is in the event that a disclosure is going to be happening anyway. Here's the reasons why disclosure can occur. 1, 2, 3, right? And we're not saying that the court has to, you have to go to a court to get it ordered, because surely, the government's not going to order disclosure. The government's going to be ordered to provide the disclosure, right? So I don't. Your argument would make sense to me, Mr. Arbor, if we were talking about an act of something that has to be disclosed, but we're talking about something that's disclosed after the fact potentially, right? And a court, by adding this particular line, a court has already made the decision that order has to be, it's been authorized already to be disclosed. Unless I'm missing something, I think we're conflating two different issues here to some degree. What's your take on that?
Thank you, Mr. Chair, for the question. So I appreciate the intent behind the consideration or my understanding there. Because the text of the amendment sets out that replaces the is necessary to protect the telecom system with only if authorized by an order, and then sets out that the order is granted by an application by the minister to the federal court. That sets the gating factor there. So A or B would give us some alternative mechanisms, but they're pretty limited. Like, we'd essentially be relying on the telecom operator we collected the information from to consent to its disclosure.
Yeah, fair enough. Thank you.
No more further discussion. Call for a vote. All in favor? Show of hands. Okay. We're good? No? No? Okay. No. Okay, call for a vote.
No, we don't need a recorded vote, but just show of hands.
That's what I just said, show of hands.
Yeah, and you said no, you said all in
okay, I'm
favor, and then
sorry.
you never said
My
those
apologies.
opposed.
Request a recorded vote.
Okay, there we go.
Thank you, Mr. Keurig.
Ms. O'Connell?
No.
No.
Mr. Gay,
No.
Mr. McKinnon,
No.
Monsieur Chiffier,
No.
Mr. Shipley,
Yes.
Mr. Lloyd,
Yes.
Mr. Mutz,
Yes.
Mr. Couric,
Yes.
Madame Michaud,
Contre.
Monsieur Julian,
Entre.
2 nays, 9 yeas.
CPC 12.1 was defeated. I wanna make sure. After the confusion, I want to make sure. Okay. G6, Mr. Gahir.
Thank you, Chair. This amendment specifies that when confidential information is shared between parties under 15.6, that information must continue to be treated as confidential. Under 15.6, information, including confidential information, can be shared between certain parties, including the Minister of Innovation, Science and Industry, the Minister of Public Safety, or the Minister of National Defense, for example. Thank you.
Discussion? Shall G6 carry? All in favor? Carried. CPC 13. Okay. Through. CPC 14. Withdrew. BQ 9. Note, if BQ 9 is moved, CPC 15 cannot be moved as they are identical.
OK, merci, Monsieur le Président. Alors, BQ 9 est...
Thank you. BQ 9 is quite simple. I will read the amendment. We would be adding on line 29 on page 7 the following. If an exchange of information occurs under agreement or arrangement with the government of a foreign state or with an international organization established by the governments of foreign states, the minister must, without delay, notify the person to whom the information relates of the disclosure and of the state or organization that received it. It was an additional protection of the personal information shared by the government, and so to protect privacy. That is something that was requested by witnesses.
Any discussion? Ms. O'Connell?
I think we just feel this amendment is unnecessary given the other protections, like in section 15.7, because the sharing of confidential information to many groups, there's already restrictions on that, and how any non-confidential information can be disclosed is, again, it's already addressed. And that 15.53 only allows for the disclosure of confidential information in very limited circumstances. So again, we don't disagree with the intent. We just think it's redundant because it's already addressed in terms of how information can be shared. Earlier, we dealt with adding clear language around the Privacy Act provisions, and then anything around confidential information, that confidentiality, which is what we just passed in the previous Government 6, that confidentiality carries with it even when those limited circumstances when the information is shared. So we just feel it's not a necessary provision that's already addressed in those other sections.
Thanks very much, Chair. My other committee is the Access to Information Ethics, Privacy and Ethics Committee, and while notably it prosecutes liberal scandals, it also does a lot with privacy. So I would ask the officials if they could weigh in, and I appreciate Ms. O'Connell's statement about not being necessary, but I would ask if the officials could weigh in about specific application of the privacy-related sphere in this, and whether the amendments make a notable difference compared to what is currently listed in the Act versus what is in Bill C-26, and its application to some of the myriad of privacy rules associated with that overlap here.
Thank you, Mr. Chair, for the question. Perhaps I'd first start with the protections that exist and then explain what this amendment would do over and above that. There are already restrictions in the text on the ability to share confidential information, which would include personal information. 15.7 paragraph 1 has a prohibition on sharing information that's designated as confidential. And furthermore, paragraph 2 states that even sharing non-confidential information cannot be done if it would be used in a purpose that would be penal. And then we've had some amendments today to further clarify the designation of personal information as confidential in the application of the Privacy Act. What this amendment would do is specify that sharing any of the information that is collected with another party has a notification requirement that goes with it. So it doesn't prohibit the sharing, it says we need to notify the parties. Given that personal information would already be restricted from being shared to begin with, essentially we'd be talking about notifying the telecom operators each time we share non-sensitive information with an ally. Essentially, we'd collect a range of information such as describe the number of cyber incidents over the past year and the causes of those amendments, the causes of those incidents. Yes. Were we to share that information, we then have to, with an ally, we then have to notify each of the telcos when we shared that information. So it has, on the one hand, there are protections regarding personal information that exist. On the other, it does create an unusual circumstance where we would be notifying the telecom community of international relations discussions.
Just to follow up on that, so I know throughout, and there's often exceptions. So for national security and whatnot, how can Canadians trust that when an exception may be laid out in either C26 as it is notable, and this is larger than the conversation about this current section, but the minister is given discretion quite often to ensure that they can use information if it's related to national security, et cetera. How can Canadians trust that that right balance is struck? This is a little bit of a bigger conversation, but I think it'll help speed up some of the other amendments forthcoming. If you could maybe outline just the processes that are in place to ensure that privacy is in fact protected, and that when an exemption may be laid out in legislation, that's not opening up for abuse.
Thank you, Mr. Chair, for the question. So first, starting with the scope of the information that can be collected, it can only be collected if it's related to an order to protect the Canadian telecommunications system, to inform the development of an order or the enforcement or promoting compliance with an order. Off the bat, that the information of concern is not personal information. It is corporate information of the telecom operators that own and operate the telecom networks that we're dealing with. The personal information, web browsing behavior, or what have you, is not germane to that, and we cannot collect information that's out of the scope of the existing text. The amendments that were passed just now further make it clear that in the provisions for designating confidentiality, so there's a number of factors that allow for what information can be designated as confidential. It makes it clear that personal and de-identified information is captured as there, along with making it clear that the Privacy Act applies. And then finally, under 15.7, there are two provisions that state, for instance, that any information that was designated as confidential, for instance, personal information that was designated as confidential, cannot be disclosed internationally within this scope. At a few different steps, either in terms of what information can be collected at the outset or if by some chance personal information was provided by accident, the limitations on what we could do with that information. Set out a regime here that does not involve ministerial discretion.
Thank you. Thanks.
J'avais les mêmes questions que Monsieur Courette.
I had the same questions as Mr. Barrett.
Mr. Motz, please.
You just answered my question as well.
Okay.
Thank you.
Any other discussions? Show of hands. What? Shall BQ 9 carry? All in favor? All opposed? Defeated. G61. G61, please.
Thank you, Chair. This one just adds clarity that the Privacy Act will supersede provisions in the bill. Thank you.
Further discussion? Shall G61 carry? All in favor? Carried. C15.1?
Yes.
CPC 15.1?
Thank you, Chair. I'll be moving CPC 15.1. This amendment will require the minister to prepare a report stating the number of times an order prevailed over a decision of the CRTC made on this act and be tabled in Parliament.
Ms. O'Connell, please.
So our concerns with this was just, again, that it be contained within the annual report, not a separate report. So as long as we can use that language from earlier, then we're fine. Can we just get clarity that that is the case?
I wish it was that simple. Found out there was a little glitch in that one earlier, so maybe the chair and the clerk will be able to help us a little bit on that. Can we roll that into part of what we were talking about and try and come back next time?
We're going to suspend for a couple minutes.
Oh, boy. It's never that easy, eh?
please. Yep. Mr. Shipley, please.
Just ask for unanimous consent to withdraw our last motion that we put on the floor.
15.1's withdrew. 6.2, G62?
No, just it's CPC 15.1. He's asking UC to withdraw it.
Yep. Unanimous consent to withdraw CPC 15.1? Thank you. G62?
Yes.
G62. If 6.2 is adopted, G63 becomes moot. Ms. O'Connell, please.
Thank you. This kind of carries on the earlier discussion about just creating a simpler annual reporting amendment. So it encompasses, I think, some of what the Conservatives were trying to do in the last amendment in terms of the report must be include the number of orders that were made in the fiscal year, including timelines of 15 days. So we think that just captures some of what was trying to be achieved, notwithstanding that I understand the Conservatives want to come back with another amendment later just to clean up some other language. So yes, thanks.
Anyone else?
And sorry, I didn't read your next one while we were standing up talking.
Are you suggesting, I don't know, but you could correct me if I'm wrong, that the only thing that would be missing from the last one is that it's the CRTC, any regulation that prevails over such a CRTC decision, if I'm understanding that that was kind of the sticking point that you wanted included.
Included in that report, your motion says. Did that cover it all? Yep.
So do you want to put some of that language and
Well,
into this one?
Sure, as a sub.
G62, and we're making a sub-amendment? Okay.
Included in the report, details on how many, I'm reading yours, sorry. It's been a long day, I agree. Sorry, is there,
We suspend for 2 minutes and get it in writing from you, Mr. Shipley.
all right.
Thank you. You read the sub-amendment.
After how many orders were issued, and report the number of times an order prevailed over decision of the CRTC made under this act.
Any further discussions on the sub-amendment?
Can you say it one more time?
We would be adding at the end of 6.2 how many orders were issued and the number of times an order prevailed over decision of the CRTC made under this act. That's the only part we're adding is that one sentence into the current report.
Okay. All those in favor of the sub-amendment? Shall G62 carry as amended? G63 can only be moved if G63 was not moved or defeated. Does that make sense? That doesn't make sense?
Yeah, so now we are.
No, G62.
Yes, so now we're NDP 9 now.
Yeah. My apologies, we're on NDP 9. If NDP 9 is moved, CPC 16 cannot be moved as they are identical.
So,
Mr. Julian. Mr. Julian.
Thank you, Mr. Chair. And this is another key decision point in terms of what we've repeatedly heard on the best route forward to improve Bill C-26. What we heard from members of the coalition, and I'll remind you that the organizations involved include the Privacy and Access Council of Canada, Open Media, the National Council of Canadian Muslims, Ligue des Droits et Libertés, International Civil Liberties Monitoring Group, Canadian Civil Liberties Association, all of whom have said that the important component to ensure public interest is protected is provision for special advocates. And so what this would do is add after line 13 on page 8 the following. A judge must appoint a person from a list established by the minister to act as a special advocate in the proceeding after hearing representations from the applicant and minister and after giving particular consideration and weight to the preferences of the applicant. And then by adding, after line 28 on page 8, the following. On the request of the minister, the judge may exempt the minister from the obligation to provide the special advocate with a copy of information if the judge is satisfied that the information does not enable the applicant to be reasonably informed of the case made by the minister. The provisions of special advocate, I won't read all of the amendment. I know that members, my colleagues around the table have had the chance to thoroughly review NDP 9. But the reality is that special advocates are top secret, security cleared, private practice lawyers, independent of government. And we've already seen special advocates in protecting the interests of, for example, permanent residents or foreign nationals subject to a security clearance, certificate, or other proceedings under the Immigration and Refugee Protection Act. And so currently there is a list of special advocates who are cleared to defend individuals in matters like this with the Immigration and Refugee Protection Act. There are currently 10 special advocates that are available. And so this is clear testimony that we heard from numerous witnesses, from the coalition members that I mentioned, some of Canada's most reputable groups. And there is no doubt that having in place a special advocate would improve the legislation. And so I wanted to move NDP 9.
Thank you, Mr. Julian. We have a ruling, and I'm going to read it out as a chair. The amendment seeks to authorize a judge to appoint a person from a list established by the minister to act as a special advocate in the proceeding, creating a new and distinct spending to be drawn from the Treasury. As House of Commons Procedure and Practice, 3rd edition states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge of the public treasury or if it extends the objects or purposes, or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of the chair, and for the above-mentioned reason, the appointment of a special advocate imposes a charge on the public treasury. Therefore, I rule the amendment inadmissible.
So, Mr. Chair, I have a lot of respect for you, but I am going to present a couple of pieces of information that I believe are relevant, and then I will be asking the committee on whether or not they agree with your ruling. First off, we have had in the past speakers, I'm thinking of 2003 Speaker Milligan, who found that a royal recommendation was not required because the bill did not immediately require the expenditure of public funds. And in 2010, Speaker Milligan also found that Bill C-300 did not require a royal recommendation, as the bill only provided for a requirement to undertake such a program, but did not stipulate how the government should execute the program. I think it's fair to say that special advocates exist already. And we're not talking about an additional charge to the public treasury. And the reality is the government could choose to make a royal recommendation, but I think it's fair to say that the jurisprudence on this and Speaker Milligan's repeated rulings, both in 2003 and 2010, indicate to this committee that given that the special advocate program is already in place, that there isn't an additional charge to the public treasury. And so on that basis, I would challenge your ruling with deep respect for the work you do and the slow cadence that you've brought to our clause-by-clause deliberations.
Call for a vote.
Again, we always get a little confused. Can we just confirm how this vote works?
Mr. Chair, I believe that...
Shall the decision of the chair be sustained? He doesn't have his hand up.
Yeah, that's
Second.
Ms. O'Connell? Yes. Mr. Biddle?
Yes.
Mr. Gay?
Yes.
Mr. McKinnon?
Yes.
Monsieur Chiffquier?
Oui.
Mr. Shipley?
No.
Mr. Lloyd?
No.
Mr. Mutz?
No.
Mr. Currat?
No.
Madame Michaud?
En faveur.
Mr. Julian? 7 nays, 4 yeas. Il y a pas de-
Shall clause 2 carried as amended? All in favor?
Mm-hmm.
Clause 2 carried as amended. All in favor? Carried. We're getting tired. Yeah, good. Okay. Yep. Shall clause 3 carry? All in favor? On division, sorry. Yep. Shall clause 4 carry? On division. Shall clause 5 carry? On division. Shall clause 6 carry? Okay.
7.
Clause 7?
You have BQ 10.
Okay.
That's one. Madame Michaud, if she wants to know that, ask her.
Yeah. So these guys. Okay, we'll go to BQ 10.
Merci, Monsieur le Président. Alors,
Thank you, Mr. Chair. We've had many discussions with telecommunications providers that were concerned, and this has to do with sanctions and violations and ongoing violations. And I can read 72 1.171. Not the paragraph, but anyway, you understand. So whenever there is an order under 15.1 or 15.2 or paragraph 15.8a is a violation, and the penalty would be A. In the case of an individual not exceeding 25,000 and for subsequent contravention not exceeding 50,000, in any other case not exceeding 10 million and for a subsequent contravention not exceeding 15. And 72.132, a violation that is continued on more than one day constitutes a separate violation in respect of each day during which it is continued. So we would be removing lines 24 to 26 on page 11, because for big companies, $10 million or $15 million is a lot of money. And so one could imagine that for small businesses, it would not be doable. It's too much. And this is a recommendation from the Canadian Chamber of Commerce to remove it. Because in the coming days, or in the following days, the companies will be trying to resolve the issue. And so a violation could have additional issues if things are not resolved in one day. Then there could be administrative sanctions. This could also lead to service interruptions, and there wouldn't be enough time to administer corrective measures to solve the vulnerabilities. Removing this paragraph would allow the government to apply fines when needed.
No discussion? Ms. O'Connell?
Again, I think we understand the intention is to not also bring undue harm to, say, smaller companies or enterprises that may be subject to this. I think, though, we are just concerned that for the big players in this space, that if a fine, for example, were too small, that it's really not an incentive to comply, and it would be kind of a cost of doing business just to move forward and pay the fine. But perhaps I'll just quickly ask officials, how do you see this, or do you see provisions in the bill to accomplish what Madame Michaud is concerned about in terms of making sure that penalties are not overly harming to smaller sized businesses?
Thank you, Mr. Chair, for the question. Indeed, subsection 72.133(1) sets out the set of factors that must be taken into consideration in determining the amount of the penalty. It includes the nature and scope of the violation, any past history here, but also importantly, the person's ability to pay the penalty. Furthermore, subsection 2 states that the purpose of the penalty is to promote compliance and not to punish. So this is parallel to existing administrative monetary penalties and set out constraints such that any penalty must be reasonable when taking into consideration these factors. We'll also be taking up the issue of due diligence subsequently. Just to build on that, in this circumstance, it is the larger carriers that have revenues in the north of $15 billion per year, such where there can be the maximum size of the penalty is geared towards the largest players, because otherwise there can be this, if it costs $20 million to replace some equipment, but the maximum penalty is $10 million, maybe I will just pay it. But these protections have been geared such that when taking into consideration the interests of small business, that they not be unreasonable and not be out of the scope of the person's ability to pay.
Thanks. So, I would just say, so with that being said, I think the concerns around protecting smaller businesses are built in with some of the reasonableness and ability to pay. So although I agree with this, I think it's covered in other sections, and I wouldn't want the unintended consequence of trying to protect the smaller players in this space to actually allow the bigger players, as the example that was just provided, to do nothing because a fine is cheaper. So I can't support it in that sense, but I feel confident that the protections are there in other sections.
Thank you. Madame Michaud.
Merci beaucoup pour les explications.
Thank you very much for those explanations. If we have criteria for the penalties, why mention the maximum amounts? But you said that the maximum amounts are linked to the ability to pay that bigger companies have. Is it common practice to have a maximum penalty to show what it could be? Is that something that has to be given? Because I think that it's something that scares small businesses. I understand that it could be adjusted after with different criteria, but is it usual to have the maximum penalties?
Merci, Monsieur le Président.
Thank you, Mr. Chair, for the question. In writing such a bill, it is normal to have a maximum penalty. There's always a maximum amount. In a sector that has a lot of variety in the size of service providers, there are some that have revenues of billions of dollars and some that are small companies. And so it is normal to have a high maximum penalty so that there can be an appropriate penalty for the larger players, but there are criteria to protect small businesses. Thank you.
Mr. Motz, please.
I had my questions answered again. These officials are just so officious today. It's amazing. Thank you.
Okay. Yes.
Est-ce que je peux demander
Madame
un
Michaud.
vote par appel nominaire?
I would like to ask for a recorded vote for this amendment, please.
Thank you. Recorded vote, please.
Ms. O'Connell?
No?
Mr. Biddle?
No.
Mr. Gay? No. Mr. McKinnon?
No.
Monsieur Chiffquier?
No.
Mr. Shipley?
No.
Mr. Lloyd?
No.
Mr. Motz?
No.
Mr. Kirk?
No.
Madame Michaud?
En faveur.
Monsieur Julien?
No, contre.
Yeas 1, 10 against. Nays.
Defeated. CPC 17.
Please, this amendment would require the government to consider whether telecom exercise due diligence to prevent the violation when determining an administrative monetary penalty. I think that's pretty self-explanatory, what we're looking for.
Ms. O'Connell.
we think we actually have an easier solution because I think that there are a number of, it also BQ11 deals with due diligence. And so we won't support CPC 17 or BQ 11 because we actually think it's cleaner just to not support the clause, which would be clause 10. And this would allow us, or I can get to it when we get there, but in terms of, it would have the effect of allowing due diligence in preceding the violation. So we think it's easier than amending is just to delete the clause.
Like all
I
the
can
violations?
read it out, but we're just not there yet.
Okay, what government one are you talking to? Sure. 9-1?
It would be, just to clarify, when we get to CPC 18 in
Yes.
clause 10, do you want me to get there or just wait till we get there? But basically, the amendments that are being proposed right now all deal with due diligence, and we think we just have a cleaner way of dealing with it. So I don't know if you want to park those and deal with clause 10 to make sure everyone's comfortable, or what the process would be. But that's why we're not supporting these amendments, because we just think we have a cleaner way of addressing the same issue.
Can we park this?
Madame, Monsieur?
Je veux juste m'assurer de bien comprendre.
I just want to be sure that I understand for paragraph 10 before voting on CPC 17 or BQ 11 that have the same intention. 10 says paragraph 7 I'm not sure what removing the paragraph would do for people seeking to defend themselves. Perhaps Ms. O'Connell could explain further. We would be able to better understand.
I think it would be simple to let officials explain the rationale of why deleting the clause would have the effect of what I think everyone's in agreement with.
Thank you, Mr. Chair, for the question. So the Telecommunications Act, as drafted currently, has a due diligence defense that applies broadly across the course of the Act. Clause 10 of C26 would insert an exception that would essentially have that orders under C26 would not be subject to due diligence. Rather than add amendments to insert due diligence back in, simply removing the exception in Clause 10 would ensure that the due diligence defense already existing in the Telecom Act would apply writ large. So just from a drafting standpoint, it avoids an exception and then reinserting new language.
Well, because we're on CPC 17, and I think BQ 11 also deals with it. So if we could park those two, if everyone, and then when we get to clause 10, if we can do what is being proposed, I think it might address everything. And if not, if committee members are not happy with that justification, we can go back to CPC 17 and BQ 11.
Apologize for missing you twice, I think. Go ahead, sorry.
Oh heavens, well, we don't want to do that again. Thanks, Chair, and I would just maybe ask the legislative clerks who often don't get the thanks they deserve in helping navigate some of this stuff. Because I know we often hear about line conflicts in sequential order. So if we were to park these and find agreement on what's being proposed, if maybe, because I think everything's been talked about on the record, would the legislative clerks be able to outline if that would essentially deal with these in sequential order and address the line conflict issue, that if I'm interpreting what's happening right and my reading of some of the amendments, it would allow us to just process efficiently while also not missing out on what I think we're trying to accomplish here with our amendment.
And the clause 7, so we'll stand clause 7 and put it at the end of the, so the old clause, not just the amendments. So BQ 10, CPC 17, BQ 11 will be postponed at the end to deal with the, so the old clause will be postponed, not just the amendment. Well, do we have UC to
unanimous consent then to park those ones, those clauses, and we'll carry on with.
So clause 8. Clause 8
is amended.
No, there's no amendment. So
Shall clause 8 carry? Yes. Everyone carried. Shall clause 9 carry? Yes. Carried. Good. Clause 10, CPC 18.
Move this amendment. Just losing track here. Oh, okay. Yeah, can we, this is very similar. Can we park this one too?
Mr. Chair, what I would suggest, we can perhaps have the debate about if you withdraw CPC 18 and we have the debate on clause 10, which would essentially delete clause 10, which would essentially do the same thing but cleaner. It's just. Okay.
I got a thumbs up.
So if the
So
conservatives withdraw.
we will withdraw that.
Okay. So then may I speak to clause 10 then?
We withdrew it.
That's 18, right? CPC 18.
Shall clause 10 carry?
No, wait, sorry, we want to amend it.
Okay, sorry.
Before I get into this, I just want to make sure with officials that I'm doing that I'm understanding correctly so that I can move the correct amendment. But essentially, as Mr. Arbor just stated, that Clause 10 creates the exception to the Telecommunications Act. So what we are doing is just removing the wording that creates that exception, which then in turn would allow for the due diligence. So this amendment would be that the proposed addition of other than, hold on, let me just make sure I have the right text here. Sorry, through the chair to, again, Mr. Arbor, if I'm just removing other than a violation under section 72.131, is that the exception that that you feel is the deletion that would then allow for due diligence?
Thank you, Mr. Chair, for the question. If it's the committee's intent to ensure that due diligence applies, Clause 10 is not needed at all.
Thank you. So it's the entire clause. So then I would propose that we will vote against Clause 10, which removes the exemption that takes away the ability for due diligence. Sorry, just wanted to make sure we were doing it as cleanly as possible.
Does 10 carry? No. Okay. Defeated? That's it? Good? Everybody? Do you want to go back or do we go to 11?
reverting to negative clause 10?
Yes.
So just be clear, so we're deleting clause 10 of the, everybody's agree with that?
Okay, so we all agree that we're deleting clause 10, just to be clear. Okay, okay. Clause 11? Or do you want to go back? Do you want to go back now?
Yeah.
So we're going back to clause 7. Okay? Clear as mud.
Withdraw.
Okay. We'll-
Okay. So,
Hmm?
where are we at?
So now we go back to Charles.
So he's withdrawing
Okay, so-
CPC 17?
Yeah, so we have VQ 11. Voulez-vous la... OK, parfait. So it's Charles clause, as a question, Charles clause.
Okay. Do these guys know that we withdrew 17?
Maybe you should...
Thank you. So CBC 17 is withdrawn.
And BQ 11.
And BQ 11 is withdrawn. Shall clause 7 carry? Yes. Yes. We agree? On division? Carried?
Okay, so 8 was carried.
8 was carried.
9 was carried.
9 was carried.
So now
We,
11.
we are in shall clause 11 carry. Good. On division. And
This is the end of part 1, I believe. So that would be a good time to break.
okay.
Adjourn.
Adjourn.
Thank you.
Cheers.